Thank you, Mr. President. Colleagues, I rise in opposition to the portion of this bill that is the so-called First Amendment Defense Act. Incredibly, I actually find this amended legislation really almost worse than before because it seems to vastly broaden the categories of people that are impacted. Because the protections contained in the bill encompass any belief, speech, or acts that are in accordance with a sincerely held religious belief regarding lawful marriage between two people. So to me, that reads any belief about what two people should be allowed to get married. So notwithstanding any federal laws, by the plain language of this legislation, it would therefore protect the viewpoint that, for example, interracial couples and interfaith couples should not receive the same treatment as other couples. In fact, it would even, if you will, protect the viewpoint, if it was sincerely religiously held, that two short people shouldn't get married, if that's your religious belief regarding marriage between two people. Another glaring problem turns on the definition of lawful. I understand from the Senate, the bill sponsor, the Senator from the 13th's comments that lawful is meant to modify marriage, and so that would be interpreted in that way to be discussing marriage that is already legal under U.S. law. However, if it modifies back to belief, and at the very least it's inartfully drafted so that there is a question, it could be interpreted as a belief regarding what is lawful, then that would protect the viewpoint that marriage should not be limited to two people. There are, as you know, a number of troubling religious sects that believe in polygamy and the forced marriage of female children to male elders. It's not drafted very, very artfully, Senator. I understand that's not your intent. In fact, the so-called Fundamentalist Church of Christ of Latter-day Saints was kind enough to very recently, I don't know if any of my other colleagues received it, mail me a hardback treatise at my home. It just came a couple weeks ago. And this manifesto had a lot of revelations from Warren Jeffs, who is currently in prison for sexual assault against children that he claimed were his spiritual wives. At the very least, this is inartfully drafted, it's inarticulately drafted, and the question exists what lawful is modifying. And if it's a belief about what should be lawful, it would then cover people with a belief that marriage could be between more than two people. Further, FATA also includes the troubling and unprecedented language that people can be discriminated against based on their sexual habits. This sanctions discrimination against single mothers, people who have had affairs, people who cohabitate, people who are divorced, people who are remarried, and many others. Further, this newly enshrined ability to discriminate would not just be limited to people or religious nonprofits. It would cover any organization or legal entity that documents or mission statement acknowledge a religious belief or purpose. Yesterday, I did some very brief internet research and discovered that both Chick-fil-A and Hobby Lobby, for example, have religious mission statements, and I'm sure that there are many others. And as the Senator from the 13th stated, it would not be difficult for a company to change their mission statement or governing documents to include a religious purpose in order to obtain the legal arguments and protections that this legislation is to provide. I'm going to walk through a number of the constitutional infirmities in this law, and please do bear with me because there are a lot of them. First of all, the bill violates the free speech clause of the U.S. Constitution because it has both content-based and viewpoint-based discrimination. Laws that target speech based on content or subject matter are subject to strict scrutiny and are presumptively unconstitutional. In Reed versus the Town of Gilbert, a church successfully challenged a sign ordinance that treated political signs more favorably than the church's meeting signs. Justice Clarence Thomas, writing for the court, explained that a law that singles out a specific subject matter for differential treatment, even if it does not target viewpoints within that subject matter, and here we are singling out religious viewpoints about marriage, is a paradigmatic example of content-based discrimination. On its face, HB 757 treats speech and activities related to marriage between two people more favorably than all other speech on all other subject matters. Moving on to viewpoint discrimination. First of all, I do disagree with the Senator from the 13th that the bill is actually neutral. I understand that by making the two people change, it was intended to get around viewpoint discrimination charges. However, it does still affirmatively single out the belief that marriage should be between one man and one woman for additional protection. It's the only one written in the law, so you can't really escape the charge of viewpoint discrimination. Judges would certainly view that. Some might agree that two people saves it. Many others would say you've still elevated a belief that marriage should be between one man and one woman above any other viewpoint related to marriage. So that's not neutral. The Supreme Court has held that the government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. In Rosenberger versus Rector and Visitors of University of Virginia, the court explained that the state university newspaper could not select for disfavored treatment student journalistic efforts with religious editorial viewpoints. In the same way, the state may not disfavor non-religious viewpoints. Unfortunately, this legislation does just that by allowing religious viewpoints and not secular viewpoints to justify trumping existing law. This bill would also violate the Establishment Clause of the U.S. Constitution in two ways. It creates a religious exemption that causes real harm to other people, and it grants discretionary powers to religious organizations and businesses that may then place a religious litmus test on who they serve. The Supreme Court has held that, at some point, accommodation may devolve into an unlawful fostering of religion. This is important. That then violates the Establishment Clause. To avoid an Establishment Clause violation, a religious exemption must be measured, and I'm quoting, so that it does not override other significant interests, and it may not impose unjustified burdens upon others. In the case of a state of Thornton v. Calder, Inc., the Supreme Court struck down a blanket exemption for Sabbatarians because it, quote, unyieldingly weighted their religious interest over all other interests, including the interests of coworkers. This legislation grants individuals and religious organizations that hold religious beliefs about marriage a blanket exemption to all laws that conflict with their religious beliefs. It fails to take into account any potential harms such exemptions would cause to others. That clearly burdens and harms others based on these single religious viewpoints regarding marriage and are therefore impermissible results under the Establishment Clause. Further, the government, under the Establishment Clause, may not give religious organizations discretionary government powers. In accordance with this bill, faith-based organizations can take state, local, or federal funds to provide services to the public and then use a religious test to determine whom they will and will not serve. This is not just unfair, but unconstitutional. In the case of Larkin v. Grendel's Den, for example, the Supreme Court overturned a law that allowed churches to veto applications for liquor licenses in their neighborhoods. The court explained that the government cannot delegate or share important discretionary governmental powers with religious institutions. However, this bill would delegate or could delegate governmental authority to religious organizations in the case of if the state is giving money to nonprofits that are religious that may run adoption agencies, homeless shelters, etc. The state is then delegating some of its authority in that area and specifically allows them to use religious criteria to determine who gets and who is denied public services. Finally, the bill does violate the Equal Protection Clause of the U.S. Constitution. In Romer versus Evans, the state of Colorado passed a law that would overturn all state and local non-discrimination protections for LGBT Coloradans and prohibit state and local governments from instituting new non-discrimination protections. A look ahead. And I think the look ahead is important to discuss because that's one of the things that we need to talk about here. The justification that they gave for that law was that it would protect those, quote, who have personal or religious objections to homosexuality. The Supreme Court, however, rejected these justifications and determined that the law was unconstitutional because it was passed to make LGBT Coloradans unequal to everyone else. And again, I think it bears repeating that the only viewpoint pulled out in a clause related to marriage between two people is the viewpoint that it should be between a man and a woman, which means it's specifically pulling out one to make that group more unequal to everybody else. In Romer versus Evans, that was directly struck down. Further, this legislation could, in the same way, nullify future efforts that our state might have or local governments might have to pass future non-discrimination protections for married LGBT Georgians. I have a couple other things I want to mention really briefly, and I know everyone's brain is spinning from all the Supreme Court cases, so these are going to be really fast. So there's legislation on the First Amendment Defense Act at the federal level. Yes, our bill's now different, but that's where this originates. Hasn't even gotten a hearing. No other state has done this. There's very, very real questions about economic impact and harm. Look, I've just walked through some finer points of constitutional law. That's something that lawyers talk about. What people out in the real world understand and hear is very different. And perception is reality, many times in a business context. There are lots of people that work in our hotel industry. You'll see a lot of letters on your desks about the 4,000 jobs they are afraid we would lose. And nothing about constitutional law matters when you're talking about that, because that's right over everyone's head. I would implore this body not to pass legislation that we know suffers from numerous constitutional problems and infirmities, simply for political reasons or to pander to a particular constituency. We should be better than that, colleagues, and moreover, we have more important business to attend to. I would ask that we all vote today against HB 757.